It's true.
15 years.
Yesterday down here.
Well, and that's the one reason I brought that up with you is I don't think he's been involved in any way with what happened during the Springfield. But we were, I'm trying to make sure everybody over in my neck of the woods understands it. I haven't really talked to him about it. I don't think he's involved in it.
Oh, is Amanda going to do it?
And I tell everybody he's a worker with me and non-management. But somebody,
How you doing?
sooner or later, somebody is going to probably try to say something. I don't want to affect him.
Mark put that.
What's that?
Mark put that to rest. I mean, that's a Mark
Yes.
level board of commissioners.
Please wait while you are joined to the conference. You are the first
We
caller to
did,
the conference. Please wait
the
while you are
Lions
joined.
asked us to, if we would, my commission doesn't like franchise fees anyway. So they asked us if we could do franchise fees and if there was anything else we could do to help expansion out. I live in Spring Creek as well. And so my commission did approve a waiver of right-of-way fees, but you've got to show that you're going to do at least $5 million investment. And that's for anybody. So, I thought I'd just let you know in case somebody ever.
Oh, that was covered.
I actually went to civil deputy and said, you know, I'll step away from this completely. And he said, nah, don't worry about it. So,
No, I wouldn't see conflict at all, because like I say, I mean, that's Mark's vision of baby and his work with the commissioners.
but I will tell you, as a resident of Spring Creek, we need
And the service that those guys are doing, when I moved from Gardnerville out there, I also realized I had fiber in my house. I mean, I didn't even do cable or satellite, because I just ran off the Wi-Fi with everything. Because it's that reliable and that good and that fast. It's the best service I've ever. It's not even close.
Yeah, I can tell you what, I was complaining today to somebody because at home I've got 6 megabytes maximum. And I was complaining about it, and the president of the Spring Creek Association, she goes, well, most people only have 1 megabyte.
Right.
It's like, it's like having a dial-up.
Right, exactly.
So,
I was giving Cooney hell about it. I need to give him some support, get that out there, change the way things are for you guys.
well, the Lions would like to see it. They know it's going to benefit their employees, not only in their personal business, but also in their mining business too.
Shannon, 10 south. Need to try to make the 12th. August meeting. I got Navy. The only way I can be in the room. That's the assistant undersecretary coming back out again, unless they don't get us in writing, but we're still waiting on their confirmation. But just saying.
What time?
It's probably gonna be 9 or 10 o'clock, and then last time it was 6 hours. But you get a lunch break. That's a lot for a fat guy.
Was your trip in yesterday?
Not good.
Okay, we're going to go ahead and get started. Good morning, everybody. Thanks so much for coming to this workshop here at NACO. I'm Maggie Stapleton, the Executive Director of NACO. This workshop is sponsored by NACO's Committee of the Emeritus. The Committee of the Emeritus is a group of former county commissioners who advise and help the NACO board. The committee was formed with the goal of preserving the institutional knowledge and expertise of past county commissioners who, due to term limits or other factors, are no longer in office, but have possess invaluable knowledge about county government in Nevada. This committee is currently chaired by NACO immediate past president, Clark County Commissioner Lawrence Weekly, and the Committee of the Emeritus provided sort of consultation as well as information and feedback to us on putting together this workshop. So we want to thank them. The purpose of today's workshop, this is the topic of this workshop is what you need to know, a detailed overview by bill of changes counties need to make as a result of laws passed in the 2019 Nevada Legislature. The purpose of this workshop is to provide counties with the understanding and the tools to effectively implement the laws passed by the legislature earlier this year. Just a few housekeeping items. Please mute your phones or computers if you're attending remotely. I heard a handful of folks call in on the phone, so just make sure to stay on mute unless you have a question, but we're only going to take questions at the very end. We'll have about 20 minutes at the very end for questions. So if you don't mind, because we've got a lot to get through, a lot of bills that we'll sort of move through pretty quickly, hold those questions to the end. Make a note if you've got a question on a specific topic or bill. The bathroom is through the door in the back of the room and on the right. Also, this workshop is eligible for credits under the Certified Public Official Program. So if you're part of that program and if you'd like to receive credit, please contact Amanda. We also, I think, have forms out here in the room that you can fill out if you're here in person. Finally, this workshop is being recorded. So not just the audio, but the video as well. If there's someone from your county who's interested in coming today but who is unable to attend, please let them know that the recording will be made available. This is the first time recording using new equipment, so we're hoping that it all works out, but today's our test run. We have tested it, but so we hope to have that up on NACO's YouTube channel by the end of the day today or Monday. So please share that with anyone from your county who may have wanted to attend next week. So without further ado, again, welcome to everyone in the room and welcome to our panel. I'll provide an introduction to our panel and then they will kick off the workshop. Wayne Carlson is here. He has had a distinguished career and is currently the president and sole owner of Public Agency Risk Management Services, Inc., which provides management services for self-insurance groups, trusts, and consults individual public entities on risk management. You all mostly know him from FOPAC. During Wayne's career, he has been active in over 9 professional organizations, taught courses in risk management and insurance at UNR, and authored numerous articles, including one entitled Risk Management for Small Governments. He has provided training and advice to cities, counties, hospitals, schools, universities, and lobbied on issues dealing with risk management, insurance, healthcare costs, and other issues. Wayne received his MBA from UNR. So welcome to Wayne. Thanks so much for coming and helping us with this workshop today. During the 2019 session of the legislature, there were changes to workers' compensation. In addition, the legislature undertook reforms addressing the removal of county commissioners from office, how to deal with claims of sexual harassment, and other impacts to county risk management. Wayne will provide an overview of those topics and those bills, including increase to cost to counties and steps local governments must take to implement those reforms. Next, we have Cathy Lewis. Cathy Lewis currently serves as the clerk treasurer in Douglas County. She was first appointed to the position in 2015 and has since been elected in 2016 and 2018. Prior to her appointment, Ms. Lewis worked in the Douglas County Finance Department. She graduated with both bachelor's and master's from Weber State in Utah and holds a CPA license. Cathy was also recently elected as the president of the Nevada Association of County Clerks and Election Officials and serves on many other commissions and boards. She is committed to continual process improvement and among her peers, Cathy has been recognized for her work ethic and dedication and is praised for her analytical problem-solving skills to benefit all local governments and her fellow clerks. And all that is true. I know that was reforms to Nevada's election laws were also a hot topic this legislative session. Changes included some to same-day voter registration and additional access for voters. Additionally, there were updates made to the protection of county personnel information, including for code enforcement, county social workers, and county managers, and further changes by the legislature that provided new mandates for clerks' offices and other county election officials. Cathy will go over some of those bills and some of those changes with some more specifics for you. Paul Liparelli is here. Paul has almost 5,000 hours serving as legal counsel for public and elected bodies in the state of Nevada. So he is the attorney on the panel today. Paul began his public lawyer career in Carson City in 1992 as their deputy district attorney and has 16 years of service with the Washoe County District Attorney. He currently serves as assistant district attorney in Washoe County. Paul and his legal team represent the county's boards, commissions, and departments in matters ranging from daily legal advice to labor negotiations and litigation. On behalf of city and county agencies, Paul has done everything from appearing in small claims court to arguing in front of the Nevada Supreme Court. He has negotiated with Wall Street firms, been an integral part of groundbreaking public-private undertakings, and helped navigate his clients through difficult legal and financial challenges. Paul is a third-generation graduate of the University of Nevada and earned his law degree at the University of Arizona College of Law. Paul, thanks again for being willing to be on our panel today. Counties are faced with new laws that impact, after this session, county operations, ranging from new requirements for filling legislative vacancies, prohibition from employment, drug screening for cannabis, the use of emerging technologies such as blockchain, as well as issues surrounding government transparency, specifically to the open meeting and public records laws. Paul will provide a summary on changes past this session to those topics and some information on implementation of those changes. And finally, Vincent Guthrow, who you know as NACO's Deputy Director. He started at NACO in January 2018. He previously served as the Government Affairs Manager for NACO in 2006 and 2007, and we convinced him to come back and work for us. Vince has over 15 years of federal, state, and local government experience, as well as background in media relations and communications. Vince is a native Nevadan and has worked on issues important to counties throughout his career. In addition to his government affairs and communications experience, Vince also worked for the state of Nevada in the Department of Conservation and Natural Resources, and he's a graduate of UNR. As mentioned, counties will experience new changes to how they serve their communities because of some of the bills passed this legislative session. Vince will address a handful of bills that are sort of more general in scope. He will also discuss a few of NACO's bills and how those will help local governments. And then finally, I will also, if we have time, discuss a few more bills at the end of the other panelists' presentations. And at the end, we will have time for questions, and we hope to wrap up about 11:45 today. So I'll turn it over to Wayne to start our panel.
Thank you, Dave. Well, the first group of topics that I was assigned relates to human resources. AB 274 talks about retaliation against whistleblowers. Of course, that's been in the national news for a different reason, but the counties are required under this bill to pass an ordinance that enacts certain procedures that protect local government officers and employees against reprisal and retaliation as provided in the statutory scheme. The ordinance has to include procedures for hearing and appeal by that person where if they allege a violation of their retaliation against them as a whistleblower. And it has to include provisions that the hearing officer for that whistleblower complaint can recommend termination of the offender. So there's limiting access to information that's submitted to NERC, to staff with a need-to-know purpose. So there's some protection there for the whistleblower. It also makes placement of false information in the whistleblower's personnel file a form of prohibited retaliation. So you can't put negative stuff in the file as a form of retaliation. It also amends a portion of the chapter of the statute to prohibit a public employee from using their power to pressure another public employee to retaliate. So the official saying, hey, I can't do it, but I think you should. That qualifies certainly as another form of retaliation. And it requires public employees to use their official authority to remedy any retaliatory action. So you have a duty affirmatively to solve the problem. If there's a whistleblower complaint and somebody's starting to retaliate, you gotta stop it. So you have some rule there. And you have to inform employees of the Whistleblower Protection Act. And what's interesting here is that the Division of Human Resources of the state was required within 30 days, required to produce a video. And that you then have to use that video or other resources to train employees within 30 days of hire and annually thereafter, and document it with a written confirmation they took the training. So on this whole subject. So you have a pretty robust scheme there. Now what we at Pool Pack did was we developed an e-learning course for that purpose. So for members of Pool Pack, it's in your e-learning resource area where you can get that training out. And we use the state video, once they got that done, incorporated that information into our e-learning course, so that accomplishes this. But that's a pretty robust requirement, and so we encourage you to get started on it. And that was effective May 25th of 2019, so compliance was immediate once that legislation was passed. The next bill is SB 153, and this bill reforms collective bargaining. So I probably should have given this one to Paul, because he's very good. So you can correct me here. But it reinstates the evergreen provision allowing union contracts to remain in place, including COLA and bonus structure, until a new contract is negotiated. So it removed that previous termination of the agreement if you didn't come to agreement. So it allows the evergreen provision. It removes the requirement for a local government employee managed relations board to conduct a hearing not later than 45 days after deciding to hear a complaint. So there's a little change in the process. It removes the wording consistent with the provisions of this chapter under the mandatory bargaining provision regarding other paid or unpaid leaves of absence. It allows agreement between the local employer and employee organization to extend beyond the terms, and redacts the previous provision. And then finally, it requires employers to provide, it repeals, rather, requiring employers to provide leave for time spent performing duties of providing services for employee organization. So there's some elements there that won't come up until your collective bargaining process starts in your next round. But there certainly are some action steps that you have to be mindful of as you prepare for those collective bargaining situations. The next bill also affected collective bargaining, that's SB 158. This revises who may be determined a supervisory employee. And this is a definitional issue. There's quite a bit of debate on that, as what is a supervisor, and can a supervisor be in a certain bargaining unit or not. And so with this legislation, an individual may not be deemed a supervisory employee for the purpose of collective bargaining simply because they perform some, but not all, of the duties of a supervisory employee as defined in the statute. This provision applies to firefighters, peace officers, and law enforcement personnel. So there's redefining who is a supervisor in the collective bargaining area. All right, the next bill, Dagny mentioned, AB 397, is misconduct of elected officials. And this is probably a reaction to a very public situation with an elected official who the employee not only filed a lawsuit against and filed complaints against, but obviously it was a sexual harassment environment, and there was a recall effort that failed, and then there was litigation that had to be resolved as well. So this bill went in to allow an elected official whose misconduct is involving areas that affect the Nevada Equal Rights Commission, and for the first time empower the Nevada Equal Rights Commission to investigate an elected official for a complaint. And if they affirm that discrimination is severe and pervasive, such that removal from office is appropriate, then it's a mandatory referral to the district court. So this mirrors some of the federal statutory language regarding severe and pervasive. So one-off is probably not going to fit that, but ongoing it would. NERC can impose monetary penalties and may require training regarding discrimination. And if there's a monetary penalty, it has to be paid out of the local official's own pocket, not be part of any taxpayer dollars for that if there is that kind of penalty imposed. Nor can it come out of campaign funds. So there is a pretty, the goal was to punish the conduct, because you can't remove an elected official except by recall or by the court action. So if it goes to court, the court would have the ability to remove him for malfeasance, and that was amended to include employment practice discrimination within that definition of malfeasance, including failure to comply with sanctions from NERC. So if the official is accused and it's found supported under NERC, it goes to court. Court has the authority to remove from office under those conditions, and failure to comply with any of the sanctions, of the monetary penalties or other sanctions that NERC imposes, is another part of the grounds that the court could use to remove. So that was a pretty significant debate on this bill, and originally it was pretty poorly written, but it got amended to this little more narrow, more doable understanding. So that's the human resource area. The next area is workers' comp. And while there's a lot more bills than these, I'm just going to highlight one that has a long-term impact. That's SB 215. And this expands to include cancer claims for first responders, including arson or fire investigators and hazardous materials officers, to the firefighters, police, ambulance. Okay, so those are all expanded lists. It limits the number of years needed to work for benefit to be considered under the program from 5 years to 1 year. So in other words, your eligibility is reduced from 5 years down to 1 year, which would be even a shorter time than the current heart-lung. Current heart-lung is 2 years of eligibility, for eligibility. What it also does is it adds a lifetime benefit to any individual who has completed 20 years of service. So right now you have police and fire that have cancer coverage, and it's during work. Now it's beyond work. It goes, if you've served 20 years, then it's lifetime. So that's similar to heart and lung. And because cancer is the second leading cause of death in the general population of Nevada, it obviously is going to have an impact financially. So just fair warning, whether you're self-insured or you're a member of PACT, it's going to increase your costs because it's going beyond employment, similar to heart and lung. So with the additional people, there may be some more claims with arson investigators who've not been eligible for this in the past. What it mainly focused on was including certain cancers that are unique to females. So that was a good outcome in the sense of the list of exposures and cancers that are covered. Because it's not every cancer, it's a lot of cancers that have been well recognized over time. It does have a provision in it, though, that says, or may become a known carcinogen that may become proven to be carcinogenic. So it's got some real unknown cost potentials in that bill. Now, if there's an employee who retired prior to July 1, 2019, the presumption is rebuttable, and the manifestation period is 3 months for each year of service up to 5 years post-employment. For claims from July 1 forward, the manifestation extends. If you're less than 20 years, it's 1 year for each year of service, and over 20, it's lifetime. So it's quite a broad expansion, and so potentially very costly one. So the main action here is to put your budget together with that in mind. There's going to be some increased costs that have come. So it was effective July 1, 2019 for claims filed after July 1, 2019. Then switching to the liability side, there was a bill, SB 245, to increase the tort cap. In the original bill, it was to essentially add a new cause of action for gross negligence with $1 million tort limit, and to increase all other to $250,000 from the current $100,000. We were successful in getting the $1 million gross negligence out because we just anticipated an enormous flood of claims relative to including gross negligence just to get larger dollar settlements. In the end, the bill increased the cap from $100,000 at present to $150,000 for claims occurring on or after July 1, 2020. Until July 1, 2022, in which the limit increases to $200,000 for claims filed on or after July 1, 2022. So we have a little time on this one to put some dollars into your budget for anticipation of this increase. Now, this was probably overdue for some level of increase, so we were able to make it a moderate increase and a stepped increase as we did in the past. All right, and the next bill is on emergency response and cyber, SB 69. You're required to establish emergency response plans that now include a review of that plan annually and a filing with the State Emergency Management Division and the agency that provides services in your jurisdiction. You're required to prepare a cybersecurity incident response plan in accordance with regulations of the Cyber Defense Coordination Office. And the plan must also be reviewed annually Now, for many of the counties and cities and school districts around the state that were members of Cool Pack, we had a contractor do a passive network assessment and give a report so that members were better prepared to start fixing some of the cyber risk. That report can be a good basis for finalizing those cybersecurity plans. And Mike Reveletti in my office, he's dialed in with the Office of Incident Response and Cybersecurity. He's dialed in with them. We just did a cyber summit here just a few weeks ago, and had a number of people, and we're trying to get a working group together on the cybersecurity issues for local governments. So it's an important area because you may be aware of it, but just in Texas in the last few months, they had 23 local government agencies hit at once with a ransomware attack. And then just in the press earlier this week, there was a national cyber or data collection agency that a lot of people use that was hit with ransomware. So they may be good at certain things, but the ransomware keeps evolving and it keeps attacking. So they expect that you are vulnerable. But we had a situation with one of our members where our cyber specialist was negotiating with the ransomware people who were demanding payment to see if they can get that number down from the original number, if we were going to pay it. And while he was on the phone with them, they pulled up that entity's website and they said, well, we know how much money they got because their financial statements are right there and you got plenty of money. You're not a poor county. They were one of our rural counties. So they're getting sophisticated, and some of them are you can negotiate with. Some of them you want to just not do it. But the message that should be in your plan is frequent backups and redundant protective systems. And make sure that all of your vendors that are accessing your network in any fashion have been vetted for their cybersecurity. Because you give them access to your air conditioning system to monitor your performance of your systems, that's a vulnerability point, and you want to make sure they have cybersecurity protection on their system if you're going to give them access. And then we just had a situation where an employee, using their cell phone, responded to a phishing attack because it came from a supervisor at her employer. And she went and bought $200 worth of credit cards. So the vulnerabilities out there. You just got to have your systems robustly looking at all of these potential pitfalls. So that's a real area for a lot of focus, and I know you don't want to waste time, taxpayers' money on this kind of thing, but it's a necessary evil. So you got to start spending a lot of time getting your systems, and don't trust your regular IT maintenance people to be cybersecurity experts. You need a cybersecurity expert to look at those regular systems, because their focus is different. It's not that they're incompetent, it's just their focus for the lay user of the system. The focus is on comfort and ease of getting access to information and passing it on to fellow employees and that sort of thing. The cybersecurity people wants to make that as difficult as possible with as few people on a need-to-know basis only having access to certain data. And that's going to irritate some folks because they say, why should I be restricted? Well, you don't have a need to know, and if you do have a need to know, then you're going to go through a bunch of hoops in order to get access with a bunch of approvals in the process. because that's how you constrain the access. Likewise, in your backup systems, you need redundant backup systems. You need them separate from your premises. They need to be off-site, in the cloud, probably in at least three different places. So all those elements are very important parts of your cybersecurity plans. Those are new requirements, and there's a lot of help out there, and certainly there's a lot of coordination that needs to be done with the state office. They have a pretty good resource to help coordinate a lot of these things. But when the attack happens, as happened to this one member, they didn't have the backups all properly done. And so they were vulnerable. And the only way they're going to get it back was with a ransom. And another entity that had an incident, they got lucky. They had regular backups. They might lose a couple days worth of data. And so they didn't wind up paying any ransom. But if you don't have the robust systems in there, the robust backup, just think about, I mean, we used to operate on pen and paper, right? Write letters and mail them. Well, now, if they can get to your system and shut it down, what are you going to do? I did this experiment with my grandkids. I made them stop using electronic devices for a weekend. They were beside themselves. So just think about that. If you were stopped from doing your job electronically today and you couldn't do it for 2 more days, you would be in a panic. So that's the importance of this. So that's the ones that I was tasked with presenting. Happy to answer any questions.
We're going to hold questions till the end. Thanks so much, Wayne. Cathy?
Well, that's a fun segue into elections, and hopefully your systems don't go down on election day. I wanted to say I was gone a couple days, and my assistant clerk wrote my bio, so she was very kind in it. Thank you for reading that. A little embarrassing. As the Clerks Association, it's very nice to have this partnership with NACO and have NACO the staff expertise, because as you can see, there's so many bills that affect, we all know local government. I know my piece, but listening to the other bills, it's amazing all the stuff that you guys get to deal with that's coming down. So I'll talk about a couple bills that are clerk specific. The first one is AB 137. That one's not too much of a change for counties. In 2017, a law went into effect that tribes could request a polling location on their tribal land. What we work on as clerks is the timing of that request. We wanted that request early enough for us to be able to plan for it. What happened in 2019 was just an addition to that, in that once the tribes requested a polling location, they didn't have to request one every election season. It's in place until they take it away. So that was a change in 137, that request that they requested in 2017 for 18 is in place until it's taken away. AB 139 now restricts 17-year-olds from marriage unless they have a court order. So that one was the only change we really saw on the clerk side, is if we issue marriage license in September to a 17-year-old, we had to make sure that they knew they had to be married by September 30th, because October 1st, when it went into effect, they would no longer be allowed to be married because they were 17 without that court order for that. So 17-year-olds cannot get married unless they have gone through the courts to get that permission for that. AB 212 and AB 362, this is the protection in the recorder's office and the clerk's office for county managers, social workers, and code enforcement. I know there's a lot of debate about what information is protected and not protected, but as the clerks, there's not a lot of change in our process. We already have a process in place to protect data from judges and sheriff deputies, and this added the positions that are protected. So the process was already in place, we're just adding to who can be protected now. And you have to have a court order for that protection too. So the big one for the clerks and the election officials is AB 345. This was the Speaker of the Assembly's omnibus bill. and this was the big changes to election. The first one is in 2018 election, the question was passed for automatic voter registration. So that means everybody who comes into DMV under a covered transaction, which is not vehicle renewal, it's something to do with their ID, is automatically registered to vote. That will go into effect January 1st. We've been working with DMV and the Secretary of State's office and the Governor's office to put those provisions in place, scheduled to go start January 1st. So on January 1st, everybody who comes into DMV will automatically be registered to vote under that covered transaction. And if they want to opt out of being registered to vote, they have to drop a card in a box at the DMV location as they walk out. They can always contact us in the clerk's office, and we can deactivate their registration on the clerk's side. But if they don't want that automatic voter registration to go through to the clerks, they have to do it within 24 hours at the DMV place. So AB 345, a couple of those provisions in there was to clarify how this process would work at the DMV for that. And another couple provisions before we get to same-day voter registration is it allows for a full provisional ballot. In the past, if someone wanted to vote provisionally, and these are voters that we can't find in our registration system, they think they're registered, but we can't find them, or they don't have the proper paperwork, we would offer them a provisional ballot, and that would give us 7 days after the election to try to figure out if they were truly registered or not, if it was just an error or if they weren't registered. That provisional ballot before this time only included the federal races, so only include president, vice president, Senate, and Assembly. I mean, the federal races, not Senate Assembly, but the Senate and the House of Representatives. Now it's a full provisional, which I personally like better. If someone's going to come in, they want to vote for their local GID or their local town or their commissioners or whatever that. So it's a full provisional starting in 2020. Then the big change is the same-day voter registration. So now voters can come to the polls and they can register to vote that day and register right to vote and vote right there. We have been working as a clerks association. We meet bi-weekly to come up with how we're going to implement it, which is the big implementation of it. These voters that come in will vote provisionally. They will vote provisionally, and then the big change, not only is trying to coordinate that work, but the big change for the clerks and for the commissioners is after the fact. After the fact, we have 10 calendar days to canvass the votes. But these 10 days are going to be different from clerks than they've ever looked before. Because during that 10 days, we have to get all our lists up to the state for the state to compare and make sure that John Doe didn't try to vote in Douglas and Carson and Washoe. So we need to make sure provisionally. So then we know what votes of those same-day registrants we'll be able to count. So we'll get that list to the state. The state will tell us, nope, this person hasn't voted anywhere else. Go ahead and count them. They'll come back to us. We'll count them. We'll change the results. I'm not sure by the percentage it'll change the results, but it could change the results. The other change is absentee ballots. In the past, they had to be in our hand by 7 o'clock on election day for them to count. But now they can be as long as they're postmarked on election day, we can count them 7 days after the fact. So those provisional ballots will be counting afterwards. So that's why I'm saying in the past, the clerks maybe, and I'm not sure in your counties if they were able to canvass a couple days after the election because they had everything buttoned up election night and they're ready to go. But it's not up to just your clerk now. It's up to the state coordination, the the absentee ballots coming in and stuff like that. So I would imagine every clerk will take till that 10th day to canvass the ballots. I did talk to Dagny early on about your NACO conference and asking when that could be scheduled so those clerks could have as much time as possible. And I think you talked about that at one of your meetings for that. So I think those are the big changes in maybe 345. I'm trying to think if there's, I'm sure you guys have other questions.
Could you just clarify something for me?
Sure.
I'm still confused under, okay, I come in and get a driver's license, Is there other information on that driver's license application that is going to put me into the voting rolls? I mean, it's more than just a driver's application, right? First of all, if I'm 16, it's not going to count, so I don't get something, right?
16 and 17-year-olds can pre-register, so they can. That information will be sent to us. We can pre-register them. They can't vote until they're 18, but they can get in our system and
Okay,
be ready
so
to
all right, so this application that you're giving me for my new driver's license has all this information. Does it also allow me to choose a party?
I meant to look at. I know they've been going back and forth. I believe you would choose the party on the card after the fact. So you'll come in and do your covered transaction with DMV. At that time, whatever information they need from that driver's license will automatically fill out our voter registration form. It will fill out your address and all that information for us. Then at the end of the transaction, they'll print out a card, and the card will have you can select a party or you can select not to be registered. The nice thing is, I personally think that might be a little confusing for voters, but the nice thing about same-day voter registration is if you get to the polls and you're like, no, I didn't want to be registered for this party, I wanted this party, you can change it at the polls. So we'll be able to correct anything that was misunderstood at the DMV. We'll be able to correct that at the polls. I talked really fast, I think that's all I have.
Thanks so much, Cathy. Paul, you're up.
I'll take the extra time because you know how lawyers are. How many county commissioners do we have in the room? Okay, and county executives? Any DAs? I want to make sure I know
Also
who my
got a couple
audience is.
people on the phone.
Okay. Good. Well, for me, the highlight of this set of bills to talk about is the open meeting law bill. And the good news is, I think it's a good bill for local governments. It didn't start out that way with the task force draft. Vincent and I were on the task force together. We had to grind pretty hard on some of the provisions to get it fixed. But there are basically 10 provisions of the open meeting law bill I want to highlight. And I'm talking about AB 70. Some of these are real simple and easy to grasp. The first one is you can now conduct public meetings by teleconference and videoconference. The catch is, if you're going to do it, you have to make sure that the people that are in the room live can hear the person who's participating by audio or video. So a good way to test that is when you call roll and you establish that you have your quorum, ask somebody in the back of the room, can you hear the person on the phone? That way you've established that you've met that requirement that everybody can hear you. The second provision is a legislative correction of the Hansen decision from the Nevada Supreme Court. That case said that a governing board, in this case the Ethics Commission, had to approve in a public meeting the filing of an appeal. And that's a very burdensome situation if you do agendas. You don't always have the time that you might need to make an appeal decision. So this open meeting law bill provides in section 2.5 that the public body may delegate the authority to the chair or executive director of the public body or an equivalent position the authority to authorize the filing of an appeal. I would urge that counties either have their county commissions adopt an ordinance or a resolution that establishes that authority so there's no question about it. We were behind the curve in Washoe County and didn't get our ordinance in place, so we recently had to have a public meeting to authorize the filing of an appeal. But we're going to get that ordinance in place, and that will allow either the chair or the county executive to authorize that. Next is the training exception to the definition of meeting. You get a quorum of members of a public body together, you have a meeting. And in order to do public records training or open meeting law training or ethics training, you would have to conduct a public meeting, which has all the
has all the requirements of agenda and recording and public comment and all that. So the task force through the AG's office was able to convince the legislature that there's little harm in allowing public bodies to get training from their lawyers or from the Ethics Commission itself on issues like ethics, open meeting law, and public records. So you can do that as long as you don't deliberate during the training session. The next change was really confirming something that we've really always done on subcommittees. If your public body forms a subcommittee, then that subcommittee is subject to the open meeting law if a majority of the membership of the subcommittee are members of the public body or staff of the public body, or the subcommittee or working group is authorized to make recommendations to the public body for the public body to take action. Most public entities that I know are already doing that with their subcommittees, but this really just confirms that you have to do it. The Blue Ribbon Commission law has been in force for state agencies for a while. The governor appoints a Blue Ribbon Commission to study mental health or homelessness, whatever. That Blue Ribbon Commission is subject to the open meeting law. Your counties and local governments are still not subject to that, so your county executive can appoint a Blue Ribbon Commission to study things. But if your county commission does it, you have to be careful under this working group definition that you might have to do that under the open meeting law. Supporting materials are now defined in the open meeting law. That's the fifth highlight of this bill. And it requires that if you supply supporting materials to a quorum of the members of your public body, that they have to be made available to the public at the same time. And there's a little room in there for what constitutes supporting materials, what a commissioner may reasonably rely on to deliberate or take action on the matters in the published agenda. So, not everything that the staff gives to commissioners is supporting material, but if it's ahead of a public meeting and would be reasonably relied on by the commissioner during the meeting, then it's supporting material. The sixth change is the facility accommodation provision, and that was pretty hotly debated on the task force. It started out requiring public bodies to accommodate as many people as were interested in participating in the meeting, and the failure to do so may cause you to have to cancel your meeting. And we explained that we don't always know how many people are going to show up. Sometimes a subject attracts the attention of an advocacy group, or how people are now with their email resources. They can summon quite a few people to a meeting pretty quickly. So this provision says that you should try. You should make reasonable efforts to accommodate the number of people that you expect to be there. So if you know you have a big deal coming up and your usual meeting room only holds 50 people, you may want to change it to an auditorium or some other place that can handle that number of people, if it's reasonable to do so and it doesn't cost a lot of extra money. One thing that has worked for us in Washoe County is we installed a video monitor about the size of the one at the end of the room there in the lobby of our chambers. So now people can watch the meeting without actually being in the chambers, and it provides not only more room, but an opportunity for people to kind of do other things and just keep an eye on the meeting. And then when they want to come into the room, if they do, we can try and accommodate that a little more easily. So the key language there is nothing in this section requires a public body to incur costs to secure a facility outside the control or jurisdiction of the public body. So you don't have to go rent a hall if you don't have one. But if you have one, you might want to consider using it. I wanted to note something that maybe we can get some help on in a future session. That the minimum notice requirement for meetings still requires the physical posting, 3 places. I don't know how you all feel, but I think that's kind of outmoded. I think most people get their notice about public meetings electronically through the internet, and websites, and emails, and all sorts of places. But we still have to go through the process of physically posting in 3 places. And if you fail to, your meeting's invalid. So if your posting person gets pulled over for speeding on the way to the posting site and doesn't get the notice posted by 9 o'clock 3 days before the meeting, you can't have your meeting. So I've argued that it's kind of a trap that could ruin a meeting and really not as important as it used to be. That's not in this bill. That's an aspiration for maybe the future. Some folks just can't get past the idea of paper and staples. But anyway.
Yes, Counselor, may I ask a question on that one?
Sure.
Besides posting, so it's actually the place you're holding the meeting and 3 other places for posting, right? Mm-hmm. Okay. And we've got the 9 a.m. Now, if those all get posted on 9 a.m., but yet the folks that are on email that are sent all the information, if theirs goes out at 9:05.
Yeah, the electronic posting is supplemental to the physical posting, so you might be okay with that, but you're going to be pretty embarrassed to explain how you were able to dispatch someone to a site to post a physical paper, but you couldn't push a button to launch the agendas.
Two different offices.
Okay, yeah. Well, do your best. I think you might be able to get away with a 5-minute delay in your electronic posting, but it's not best practice. The 7th area, which is a kind of a nice one for local governments, if you give a person an award or you recognize them for a positive achievement, honors awards, tenures, commendations, it's not subject to the notice requirement that's usually required for action involving an individual person. So your public body is going to appoint someone or take action against someone or all those kinds of things. That person's entitled to specific notice of the meeting. This provision says if you're going to pat them on the back, you don't have to go through the trouble of serving them with notice of the meeting or getting a written waiver. It's now recognized as an exception to the posting requirement.
Not even as a prank? Like we could,
There's no humor in government. The 8th item is the audio tape retention, a requirement. It used to be 1 year, now it's 3 years. So make sure you're set up to keep those things long enough. The 9th requirement is the notice of complaint, and it requires the Attorney General's office now to provide a written notice to the public body within 14 days after receiving a complaint. It has happened in the past that the AG was in the process of looking into a complaint and the public body didn't even know that was going on. So now the AG, when they receive a complaint, sends a notice to the agency saying we've received this complaint and we'll be in touch with you later. The AG has 120 days after the alleged violation to investigate and prosecute the violation. And it used to, the law used to require essentially that the AG investigate any complaint it received of an open meeting law violation, no matter how long ago it occurred. That seemed a little unfair, so the law now says 120 days after the receipt of the complaint, you have to do the investigation, and the AG may exercise his or her discretion to investigate complaints older than that, but not more than a year. So 120 days mandatory, between 120 days and a year discretionary, something older than a year, you got away with it. There's a definition in the new law about basically the standing of a person to make an open meeting law complaint. Some counties, including ours, have experienced the use of open meeting law complaints as a political tool. You get some folks fired up and they threaten to file open meeting law complaints. They certainly can, but now the AG has some discretion to determine whether the person filing the complaint really is affected by the potential violation. The language in the statute is the AG determines that the interests of the person who filed the complaint are not significantly affected by the action of the public body. If the AG determines that, then the AG does not have to follow through with the investigation, and that definition includes whether the person is a natural person and resides within the geographic area, or a business, social organization, or labor organization that has a mission or purpose to foster, protect democratic principles or promote transparency. So you can still have the ACLU and public agencies like public service agencies like that filing complaints against you, but the AG gets to determine whether they're really affected by the potential violation. I think that's good for local governments because some of these things are a nuisance. Practice pointer: when you respond to the AG's complaint, when the AG gives you the opportunity to respond to the complaint, one of the things you might want to assert is that the complaining party lacks that standing or lacks that significantly affected by the action dimension, so that you can say this is a waste of everybody's time. 11th area is the violations section, and when I give training to my public agency clients, I kind of call this the pants down provision. If you get caught committing a violation of the open meeting law, one of the things you have to do is acknowledge it and put it on the agenda of the subsequent meeting, acknowledging that you were found in violation of the open meeting law, and that stayed in the statute, but now the public body has to acknowledge the existence of the findings of the Attorney General, and not necessarily agree with it, but just basically acknowledge this is what the AG found, and we're doing our duty to put it on the agenda. Also in the violations section, there are some improvements for local governments, because the law used to basically say if you were part of a public body that was accused of a violation, you could be found guilty. There are criminal penalties, civil fines, and misdemeanor penalties. Now the law says you have to have knowledge of the violation. You can't just be blissfully sitting there and one of your colleagues on the board is violating the open meeting law. You don't even know about it. That doesn't now go against you. You have to. The statute says the violation has to occur, and you have knowledge of it, and the violation, and participates in the violation. So we don't always know what all of our colleagues know, and we don't always know when someone is messing around. But if you do know, now you can go down with the bad guy. If you don't know, you're off the hook. And lastly, on the violation section are the fines. The proponents of changes to the open meeting law were really hot on making sure that there were significant teeth in the violation of the open meeting law. So the first offense is $500, the second offense $1,000, and the third or subsequent $2,500. And those are all new. There were never fines established before, so now they're in there. And nobody wants to be the first one in Nevada to get one of these. I know we're going to try hard not to let our folks be the ones, but it is a tool for training purposes and for enforcement. If people aren't taking their obligations seriously, you can remind them that a fine could be coming their way. Another piece of good news is that the new law also now provides a safe harbor. No criminal penalty or fine may be imposed upon a member if the member violates the provision of this chapter as a result of legal advice provided by the attorney. what's the takeaway here? Call your lawyer. If your lawyer tells you you're okay, then you're not going to be punished for it. The lawyer might have some explaining to do, but if you rely on, in good faith, on the legal advice of your, and it's not just a phone book lawyer, it has to be the lawyer provided, employed or retained by the public body. So, not your neighbor who's a lawyer, not your daughter who's a lawyer. The lawyer for the agency can get you some protection if you consult them. So, that's AB 70. Did you want to add anything?
Sure. I think it's important to point out, I know this wasn't about sort of a summary of the bill, is more of what local governments need to do, but Paul's right. The bill, I think, probably ended up okay. And originally, I know some people have some heartburn. Some of our counties had some heartburn over the audio retention. That was originally proposed for 7 years and near indefinite storage. So I think local government, and also the piece on the audio and teleconference, there was a huge push from ACLU and Press Association to make that a requirement, that local bodies would be required to have audio. So I think we got a lot of flexibility in there, and it probably modernized the act a little bit to reflect new technology and again, as Paul mentioned, some of the things that people expect their government to provide them. So that was it on implementation. So I know there is a little bit of heartburn over the 3 years, but I think in exchange for all the other items that we got, it was a small price to pay, especially for the original proposal, which was 7 years. I think the ACLU asked for it indefinitely, but yeah, so that was it. That was all I would add on that.
Practice pointer on that one too. If you decide to keep it longer than the minimum period, have a policy that backs that up. Have your county policy say, we know the law says 3 years, but we're going to keep them for 5 or 10 or whatever. Don't let it be infinite or undefined, because then you really end up, if you have a practice of keeping things forever, then the expectation is you have everything. And then if you suddenly don't, it's going to be suspicious. So make your own rule and follow your own. And you'll be good. Let's move to marijuana. That's out of the I'm talking too fast for that. AB 132 is a very simple bill that says that that government employers cannot fail or refuse to hire a prospective employee because the employee submitted to a screening test and the results were positive for marijuana. Marijuana use is legal for adults, and some people are using it, and so if they test dirty, you can't use that as a basis for to fail or refuse to hire them, unless they're a firefighter, an emergency medical technician, or a person who operates a motor vehicle under a CDL, and if the employer determines that it could adversely affect the safety of others. So there's a catch-all in there. So if you have other public safety type positions that you think might be affected by someone who has marijuana in their system, you can use that as a basis. But again, the advice would be to establish a standard, probably through your HR folks. If you're going to use the catch-all, don't use it arbitrarily and capriciously. Try to set forth what other kinds of positions that you think in your county may be worthy of this protection. That's AB 132. Next, we have a bill involving appointing legislators. This last few years, there have been kind of a spike in vacancies in legislative office for all sorts of different reasons, deaths and resignations and other things. So the AB 448 kind of beefs up the appointment of legislators, and the key changes here are that if an election is not available to fill the vacancy, which is the preferred approach, and that depends on when the vacancy occurs, if the county commission is going to appoint a legislator, you now have to establish a process by which the persons may file applications to fill the vacancy. and you have to establish a specific date for the closing of the filing of applications. Maybe a good idea to have that process in place now, instead of scrambling to do it when you have a vacancy. You just never know when they're going to happen. So again, either an ordinance or a resolution would be good to establish how you're going to invite people to apply, what you're going to ask them to submit in the way of an application, and the date that you're going to close the period to file the applications. The new law also requires that the person who's applying fill out a declaration of eligibility, and the interesting part about that is that the declaration has to affirm that the address listed, which is determinative of your eligibility for that legislative office, is your actual as opposed to a constructive residence, and it was established at least 30 days prior to the closing period for the applications. So they really are focusing in on wanting to replace a vacancy in a legislative seat with a person who really lives in that legislative district. And so that has to be sworn to under oath in the verification that the applicant has to submit.
Can I ask a question with that?
Sure.
So I understand how that's done in Washington, Clark. How's it done in the rest of rural Nevada when Robin Titus represents 2 counties, so my represents 3 counties?
They figured that out. The law says that if you have a county or a vacancy involving a district with more than 1 county involved, then the process is the Board of County Commissioners of each county shall establish a process within for the persons to apply and establish the specific date. So counties have to work together on what's the process and what's the date. Again, might be well if you know you share a legislator with other counties that you kind of get that in place ahead of time so that you're not scrambling.
So 14 counties have to provide a separate ordinance of how this works together.
Do we have a legislative district with 14 counties in it?
I don't know, how big's Pete's?
Yeah.
It's over 11.
Yeah.
Tell Pete to eat healthy and not.
There's your task.
I'll text that to him.
There was an appointment last year of a legislator that was across 3 counties, Lincoln, Nye, and Clark came up with a process for this, and I believe are updating an ordinance. And I think we reached, Vince, correct me if I'm wrong, I think we reached out to them to ask them to share the ordinance and the process that they came up with for us so that other counties could use that as a model. We put a lot of work into it.
Yeah, that's correct. So we reached out to them. They are in the process of getting their DA to approve that. So once that's approved, I can send it out to the participants here at the workshop because they did do quite a bit of work on that. Mostly as a result of making multiple appointments this session, and also knowing that this law was coming. They've worked on some stuff in the interim that I think is probably really valuable for because they were involved. I think in I don't remember which district he's in off the top of my head, but the 8th appointment. So 36. There you go. So yeah, they've come up with a process that you could either model or decide which pieces work. So as soon as that gets approved by their DA, they're going to be able to publish that. So
Next subject is real estate sales. This is SB 36. As you know, if you've ever sold property as a county, there's a process that you have to follow, including appointing appraisers to determine the value. This bill has tuned up some of those requirements a little bit and has recognized that in some cases you need 2 independent appraisers to determine the value, and if only 1 independent appraisal was obtained, under certain circumstances, you can rely on that. If you use 2, then you use the average. And the law says now that when you get this number, you can't sell the property for less than the amount that is established by the appraisers. It also has introduced the reality of internet and electronic participation in real estate transactions. So it will allow a person to participate in the auction process electronically. So they don't, in some of the large counties, that's really helpful because it's a long way to the sale site in some instances. So you can participate in the auction electronically, but it also protects the counties because if that person's technology, computer goes down, internet goes down, whatever, it doesn't stop the process and it doesn't hang anything around the county's neck. The auction can be held, it says, at a public meeting or a regular place of business, and now the new law, or an internet website or other electronic medium. So that's keeping our real estate sales requirements up to date with technology. There was another change in that bill that also allows the rejection of any and all bids and the withdrawal of the real estate from sale if the board determines such action to be in the best public interest. So I think that was always kind of implicit, but now it's specifically stated in the law. I don't know where this bill came from. Maybe some initiative started in a county where they were frustrated by the old processes, but and I don't know how often counties sell properties, but if they do, your DA will help you get through this requirement or these new options for electronic participation.
So on the converse side of that one, sorry, you want to hold questions or?
You're fine.
If the public entity wants to purchase property, is there a requirement that they have to pay full value?
You know, I just don't remember that. I'd have to look it up, and I don't want to guess. But,
okay.
But I think the process is different because in the sale context, the law is trying to protect against a sweetheart deal below the determined value. If you're buying property, it's kind of a market-based situation. But again, I don't want to guess.
Unless
I could talk to you afterward and look it up. All right, let's move on to the next subject, which is removing discriminatory provisions of CC&R. There are some old subdivisions, some old properties around the state that contain discriminatory provisions in CC&R, usually racial, some religious. I bought a house in Reno that was built in right after the war, and surprised to learn that in the mid-40s they were writing CC&R that restricted ownership to only certain races of people. So this law creates a process for county recorders to develop a form that can be made available to be filed, which has the effect of removing those racial and usually racial and religious, could be ancestral, national origin, and those things. But it also added, in addition to the usual litany of those discriminatory treatments, disability, familial status, and sex. And so that means the CC&Rs can't have provisions discriminating against people with physical or mental impairments. Familial status means the fact that a person lives with a child under 18, has lawful custody of the child, is pregnant, or is beginning the process of adoption. So if there are CC&R like that, they're void by law, but this law also now allows the use of this form to be recorded in the chain of title that removes all doubt that those things are not enforceable. The recorders are supposed to be working on the development of that form. I don't know if they've completed that or not, but the real estate division of the Department of Business and Industry has also got a role in getting that form from the county recorders and making it available to people to use.
So is that one a mandate? Do we have to go out and search those CCNRs, or is just if there's a complaint brought?
You don't have to search them and affirmatively go through and remove them, but this form is now available to be used by people who encounter them and can then basically erase them.
The original bill actually did call for the search of all those titles, but it got done.
They're slowly but surely going to disappear. There may still be some out there somewhere. All right, I wanted to bring a prize, and I didn't, so I'll just call it public recognition. Anyone who can tell me the definition of blockchain will get a public accommodation during the workshop.
Well, a chain block is a big pulley unit with it.
That sounds like maybe a Eureka County. Talking about SB 162 and Senator Keycapper, who's really hot on blockchain. And he's been, over the past few legislative sessions, trying to keep Nevada law with technology. I searched the internet for the simple definition of blockchain, and I found this, which isn't bad. Picture a spreadsheet that's duplicated thousands of times across a network of computers. Then imagine that this network is designed to regularly update the spreadsheet. That's the basic understanding of blockchain. It's a technology where encrypted information is spread around in a huge network of computers, and it's purported by the people who advocate for it that it's nearly or is impenetrable. It's a foolproof way of preventing the molestation of this information once it's in this protected status. So this bill, SB 162, defines blockchain, and I'll spare you that statutory definition. But the bill says that a person who uses blockchain in the state of Nevada doesn't relinquish rights that they have in the ownership of that data. And it also commands public entities that before you replace or update an information processing system, that you consider the use of equipment and software that enables government agencies to send, accept, and process and use electronic records through and including blockchain. So if you're going to update your recorder's going to update his or her software packages, the recorder's got to give some thought to whether the new technology can use the blockchain. You're not required to install it, but you're urged to consider it because it's coming sooner or later. This bill also allows electronic transactions, and if there's a fee involved in processing an electronic transaction, the government, if it's the receiver of the information, is entitled to charge the fee that the government experiences in processing that transaction. So, sorry to be so vague about it, but blockchain is a little bit beyond my pay grade. Senator Keycapper, both this session and I think the last, sponsored bills involving this. I've been to presentations involving this subject. It's not going to go away. It's thought to eventually be able to replace a lot of transactions that used to have to be done with certification stamps, and blockchain is really potentially going to take away the need for certifications, because if it's used the way it's designed, is really essentially inherently certified. It could be used for lots of transactions involving real estate, title, and lots of those kinds of things. So, I think I'm 1 minute over.
Not too bad.
All right. The ball.
All right, my turn.
The ball is yours.
Okay. So I just want to review and highlight, before I sort of begin my presentation, just highlight a few of the NACO bill drafts first. These are all enabling, but I think it's important for county officials to know that you have these tools at your disposal now as a result of the 2019 session. The first one I want to talk about is Assembly Bill 21, so AB 21. This applies to our rural counties and those that have sort of smaller county boards pertaining to whether it's a water board or some of our counties still have TV districts and other infrastructure boards. These smaller boards in our smaller communities have had some trouble meeting a quorum. Under AB 21, through your ordinance process, again, you'd have to create an ordinance, but and there's some steps you have to take, including finding out how many members are still on the board. You could create an ordinance to make that board appointed. The other couple I wanted to mention, Senate Bill 12. For those of your counties that collect an E911 surcharge, under the provisions of Senate Bill 12, the 911 advisory boards are now authorized and enabled to utilize revenues collected from that surcharge to audit they can now use that fee and that revenue to fund an audit of the fee collection system. This actually did come from Washoe County, but Pershing County has the same issue and the same need, and there's a couple others as well. So you're enabled to do that now under Senate Bill 12. And for just a quick thing on that, the legislation, the law outlines what the uses of that fund, what you can use that fund for, and this expands the use of that and enables the use for that purpose. Also, this session was Senate Bill 460. It wasn't directly a NACO bill, but NACO worked with the Senate Committee on Government Affairs to address reforms to the Office of Public Administrator in our rural counties. You would have to create an ordinance, but you can make the position of the public administrator an appointed position in your county now under this provision. So those are just a few of the NACO bills I wanted to talk about and discuss some of the flexibility that local governments now have under that legislation. Moving on, I want to discuss Assembly Bill 86. Assembly Bill 86 addresses changes to governmental purchasing, including contracts and solicitations. Just a few things that were changed under Assembly Bill 86. It's a pretty large bill, but I just want to highlight a few of the changes. There used to be a $25,000 threshold for maintaining bids. That threshold has been removed. All bids that come into your county on items that you solicit there has to be a record kept of those. They've also changed some of the dynamics of what needs to be maintained. You have to maintain what the minimum qualifications were for the solicitation, the method of how the contract will be and was awarded, and a notification of the period of protest. There's a huge NRS that covers governmental purchasing, so you'd want to go into that, but those are some of the updates to that NRS. It's 332.068. It covers that. Under this law also, if the estimated annual amount of an award or contract exceeds $100,000, the local governing body will give preferences to bids that use recycled products. So under these, there's a few provisions even within that. The recycled products need to be a suitable replacement for what you would use if you were using sort of a first-time product. But you can also reject that requirement if it increased costs. So it has to be if you decide that the cost increase is too much, you can reject it based on that. The other thing is it updated the law and allows the use of online bidding, as long as there's two provisions here. But it doesn't, you can't require, so if someone uses an online bidding process, the bidder or the offerer, you can't charge them more to use the online bidding system. If you make that available, it needs to be, it can't be more expensive than what it would cost if they submitted something in paper. But it also, there are some security measures that have to be undertaken also by the local government to protect the rights of the person offering the bid. And it also can't necessarily increase costs to local government. So if you use an existing system that you would like to expand for this purpose, you may. If you want to absorb that cost, you can. It's elective. But so those are some of the provisions under AB 86. Yep.
Is that mandatory or just optional?
It's optional.
Optional.
Yeah, correct. So yeah, the bill says may now use, so it's not a requirement. But I think some people are, I think some DAs and boards are unsure about developing new technology if it's not allowed for in legislation. So this would allow that to happen. So. Moving to Assembly Bill 301, there was attempts by the legislature this session to deal and address deaths in county jails, inmate deaths in county jails. Under the provisions of AB 301, the sheriff's office usually, which is who runs the jail, they, within 48 hours of the death of an inmate, it doesn't matter the reason, whether it's suicide or some other reason, the sheriff has to report that to the Board of County Commissioners. And there's some requirements in the legislation about what the information needs to include. So usually it's demographic information and circumstances surrounding the death. So the sheriff's office now has 48 hours to report that information. Some things that the Board of County Commissioners has to do as a result of AB 301 is that twice a year, and the suggestion is to do it once every 6 months, they need to have an item on their agenda that covers death and safety in county jails, and they need to discuss any deaths that may have happened within the previous 6 months. So if you held a meeting in June and there were 2 deaths between January and June, you need to discuss those at a public meeting. And the hope would be that the sheriff would be there to discuss a report that is now needed to be provided to the Board of County Commissioners twice a year, and that report needs to provide sort of an aggregate information regarding any deaths that may have occurred at county jails. That requirement was always there for Clark County. There's a population provision in the bill, but that population cap has been removed. It is now a mandate for all counties. Sheriffs and Chiefs Association worked a lot on this bill to roll back some of the mandates, but yeah, that's a new provision under 301. So,
Vincent, I just remind you that there was existing statute requiring the commissioners to inspect the jail quarterly, right? Inquire about the well-being of the inmates. So that some boards get lazy on that or forget about it. So just a reminder that in addition to that, you now have this.
Correct, and adding on to that, another provision in 301 is that the Board of County Commissioners and the Sheriff's Office must make reasonable steps to prevent suicide or death in the jails. I mean, I sort of think that's a given, but it's now in law. So,
and then we had an incident of claim that arose from suicide during the legislative process, so that brought it to light. But as a result of that, we're doing jail audits, going to each of the jails. We're working out a schedule, trying to implement a jail audit for all the counties in our pool over the next 3 years. We've done quite a few of them so far. And that's to help the counties bring their jails up to standards to address these kinds of issues in advance so we don't have the incidents.
So just who is it? The county that the jail is housed in, where we house Clark County prisoners? Does the sheriff report to the Clark County Commissioner or to the Lincoln County Commissioner?
it's whatever. My understanding is it's the jail that's under your purview. So if you manage that jail, then the sheriff would need to provide you information from that jail. Yeah, he wouldn't be responsible for, even if your prisoners happen to be somewhere else. else. It's not based on prisoner, it's based on
The jail.
the
facility.
Correct.
Okay.
Facility. Moving to a little bit lighter topic. AB 413. This bill is about, it's a pretty simple bill. If you have a item on your agenda that impacts business, you must present a business impact statement as part of that agenda, and that must be presented on agenda at least 10 days prior to considering the rule or adoption, or the rule or ordinance for final adoption. Under AB 413, it can null and void the action if a business impact statement is not included on the agenda and posted properly. Let's see. SB 67. This takes up the issue of local emergency management organizations. It is now required that every local government has a local, every county has a local emergency management organization. One provision that I wanted to highlight in the bill that I think is probably a positive one for local government, even though there's this requirement, you can create regional local government, local emergency management organizations across counties. You can do that through interlocal agreements. So if you have sort of 3 small counties next to each other, and you all sort of want to go in regionally, and it makes sense to do that, you can do that through interlocal agreement. SB 111, also very straightforward, but something I wanted to highlight for any fiscal officers in the room. The SB 111 made a change to the ending fund balance that is not subject to union negotiations. It used to be 25%. The legislature lowered that to 16.67%. This bill actually didn't receive a lot of opposition because it's sort of in line with financial reporting to some degree. But that's a new requirement under SB 111, so it lowers that threshold. Senate Bill 207, sort of turning the page to public works jobs and prevailing wage jobs. SB 207 is called the, I should have written this down, but it's the Apprenticeship Utilization Act. This bill requires that if a person is trained on a particular, in a particular field, 10% of the hours for the job mandated need to be completed by apprenticeships. If apprentices are not available in your local area, you will be, the county is required, or the local entity is required to request a waiver. NACO has been monitoring this pretty extensively, but the Office of the Labor Commissioner has developed a pretty simple sort of one-page process to request and certify the waiver, but it is incumbent upon the local government to submit the waiver. So that's SB 207.
Prior to the work or after the work?
Prior. Good question. Prior to the work. And lastly, sort of on this theme of local government transparency, Senate Bill 287. So not only were there reforms and updates made to the public, or to the open meeting law, there was also reforms made to the public records law this session. This is a bill that we actually had a hearing on the last day of session, so that was fun. There's a ton of stuff in this bill, but I just want to highlight some of the changes that I think are pretty that local government and counties need to take into effect. So under the provisions of SB 287, the local governing body must do each of the following 5 things. It is now written in law that when requested of a public record of a public agency, the default should always be that the public record should be provided promptly, whether that's an inspection of books or actual providing of the record. So if the record is available, I would urge counties to make that available to the public, as long as there's no redacting or private information there. But I think as a matter of business, it'll save you some heartache if you can just do it immediately. If the public record is not available immediately, the local government needs to provide notice in writing within 5 business days. And the key change here is that you must provide an explanation of why the public record is not available and the earliest date that you believe the record would be available. So moving forward on that, again, so the key there is the 5 business day trigger. So you need to provide in writing to the person requesting the public record. You need to let them know it's not available immediately, and B, you need to tell them when you think it's going to be available. If for some reason, let's say you say, we'll have all of these title records available in 20 days. If it's not available under that time period, you then need to provide, again, a new date, and you need to explain why it's not available, why you weren't able to get it. I mean, it could be a simple explanation, right? The software was down at the vendor or whatever, but you need to explain that, again, in writing. If you do not have legal custody of the record, totally understandable, you need to notify the requester in writing that you do not have legal custody of something. So therefore, that's not a public record for you, but you just need to provide that to the requester in writing. And then the fifth piece is, we really got this language pared down, and I think this is just sort of a customer, just caveating all this, I just think it's a customer service issue. The local government needs to make a reasonable effort to assist the requester of the public record to maximize the likelihood that the requester would receive the information and the public record that they're seeking. So, from the sponsors, the reason why this provision is in law now is they're trying to create a partnership between the public and government to ultimately get them the record that they're looking for. And ultimately, I think this could help local government, because if you have someone come in and says, I want all of your records on anything where the word jail was mentioned, right? So that would take a ton of time. But if you can work with the requester, and maybe they are looking for suicide records for the past 2 years, that would help us, A, supply the public record, B, look like good actors, and limit the amount of resources that you spend on finding the public record and providing it to them. So that's...
Can I chime in on that?
Yes, please do.
Yesterday I talked to a newspaper, television reporter who sent a public records request. Our tech services people ran the query through email, 3,000 hits. We called the guy and said, we got 3,000 items we have to review for confidentiality and other stuff. It's going to take us a few weeks to do that. If you want to refine your search to something more specific, we can probably cut that number down. So I suggested to him, he was looking for information concerning this individual person who was subject to prosecution. And we conflicted off and gave the case to Lyon County. He was looking for that person, emails concerning that person. But the way he formulated his request, it led to all these extraneous items. So I suggested a new query to him. He agreed, 10 items. So step one, not everybody who makes a records request is a jerk. So if you work with some of them, they'll be able to get what they need faster. Some of them are jerks. They won't cooperate with you, and you just have to deal with that the way it is. But the other point, to Vincent's comment, none of us want to be the poster child at the next legislative session as the government who did a cruddy job of responding to a public records request. And the advocates of the Public Records Bill, as it was initially written, which was terribly onerous, were citing examples of bad actors, governments who were not doing a good job responding to public records requests, and it almost caused the rest of us to go down the tubes with the bad actors. So good faith is really important. I'm sure you all agree as citizens that access to government records is important. This is an important part of what governments do, and so setting that tone, like you're saying, creating sort of a partnership kind of a feeling will keep us from being subject to arguments in the legislature that harsh laws are needed to reform these misbehaving governments.
Yes, could you clarify something for me on that?
Sure.
I remember a story a while ago, I think it was attending an Attorney Conference, and they were talking about the commissioners using their cell phones. And of course, while you're looking at them and they're down there doing this, and they don't know that you aren't deliberating. So a public records request came in, but these were all private cell phones. I understood because it wasn't public records per se, but we were subject to it, and they had to get a subpoena or something? How does that work?
Well, there was a case, I think, in Lyon County where person
I was thinking it was Tonopah, that was,
It was Nye County. It was Lyon.
not, oh, well, okay.
Nye County.
Maybe there's multiple, but
that was Nye County, what?
Visual, personal cell phone, county cell phone. I don't let my clients and my colleagues talk to me on my personal cell phone because I don't want to have to supply it pursuant to a public records
Okay, well,
request.
tell me how that works.
So,
If
if
they're
you only have one phone and you are using it for county business, it is subject to public records requests, and you will have to make it available to have those items taken off your phone and provided. So it's a very sticky area. My advice to my clients is don't do it. Use email. It's backed up through your county systems. You know, it's easy to search emails, and your tech services people can find that stuff. If you use your cell phone, you're in peril and at risk of having to make it available to be searched for public records.
The Nevada State Supreme Court ruled in the Lyon County case that it was a case of the commissioner using her personal email address to conduct county business, and that her personal email was now going to be subject to the records law and become public. So we rectified that by giving each commissioner a county email address, issuing their county cell phone, and after January, they'll have a county issued computer as well.
Yeah, some human is going to have to go through the data on the phone and decide what is related to county business and what isn't. And I don't think any of us want to be in that position. The amount of data that we have on our cell phones now that's private, financial, family, all sorts of things is just not what we want someone else paging through to look for public records.
Okay, I've got a couple. I'll just bring up the rear here with just a handful of a few more. AB 164. This is regarding marijuana and advertising for marijuana establishments. So currently for marijuana businesses, if you have marijuana businesses in your county can pass an ordinance that is more restrictive to what the state law says in terms of regulations on marijuana businesses in a couple of areas. Location of signs, regulation of handbills, pamphlets, and newspapers, displays on or near establishments, and what was added in AB 164 was that you can regulate, you can pass an ordinance that regulates content on signs for marijuana establishments. However, only if your ordinance sets forth what specific content is prohibited. So basically, if you have marijuana establishments in the county and you have an ordinance that regulates signs and content in signs and is more restrictive than what the state law says regarding content, you have to set forth what specific content is prohibited. So in case anyone has that in an existing ordinance, it's important to know. It becomes a Second Amendment issue to prohibit content. I think that's why they...
First Amendment.
First Amendment. Hopefully it would never become a Second Amendment issue.
Good catch.
So anyway, if you do make that change in your ordinance, make sure to work closely with your DA to make sure you're not doing something you're not supposed to in light of the First Amendment. AB 344. So this is connected to 5G installations, and this is an opportunity for me to just a quick plug about 5G when it comes to your counties. Mostly, it's only the urban counties that see 5G, although everyone would love to have 5G in their counties and rural areas. And I guess the message that I want to say in relation to this is be very careful in negotiating agreements with providers who are coming into your county to build 5G, and please seek outside probably help and counsel when that happens. We've seen from the telecommunications industry they're very interested in preempting local authority, and the FCC already preempted some local authority for 5G installations nationally. The national associations and others are in a lawsuit on this, but the bottom line is you may want to look at sort of having an ordinance in place already regarding 5G. Clark County really worked hard on this and went head-to-head with some of the telecommunications companies down there and has a very tight ordinance. That ordinance is on our website, so if you wanted to look at one as a model, that would be the one to do. If you go to the resources page on our website, that is there. So anyway, this bill puts a little additional preemption into state law, but it's specific to micro wireless facilities. It's a little different than 5G. It has to do with cable installations, video providers. So it preempts local governments from restricting a video service provider from installing these micro wireless facilities on existing infrastructure. So these are small boxes, kind of like 5G, a little smaller, and it would go onto things like telephone poles or other infrastructure in the right-of-way. So the law limits counties' ability to charge additional fees, and you have to allow them to make the installation. So something to be aware of, but also an opportunity for me to make a larger plug about paying attention to 5G and what those companies are going to do when they come into your communities. Make sure you're negotiating with them. We want 5G, but you may want to think about having an ordinance in place in hopes that 5G will come to Nevada. SB 13, this was one of Nico's bills. Vince, did you cover, you can cover SB 13?
No, I didn't.
Okay. Just so that everyone is aware, this bill was passed following the 1 October event in Las Vegas, the tragic shooting down there. The county found that they didn't have the authority to establish a nonprofit, a 501 corporation, in order to collect the funds that were flowing in from around the country for the victims. And so they had to jump through a whole lot of hoops to accept those funds and make sure they were in the right type of account and then distribute them to victims, which they did and were successful at. But when we talked about this at the NACO board, found that other counties were also interested and had thought about this. If there was an emergency, what do you do? What do you do with those donations that come in? So now your county is allowed to create a nonprofit, and it might be a good idea to have that in place, sort of existing, just in case some terrible emergency event were to happen and it was needed. Basically, your board of county commissioners would have to create bylaws and articles of incorporation for that nonprofit. Other requirements are outlined in law in terms of what the board would need to do. You have to limit the uses of the funds to times of emergency. You have to put things like that in your bylaws. And the Board of County Commissioners would appoint the board for the nonprofit. So something for counties to think about to maybe have in place. SB 175 has to do with public works. So currently counties are allowed to contract with design build teams, so there's an architect and a contractor together for public works projects over $5 million and under $5 million for 2 projects a year. SB 175 removed that provision that you can do 2 design build projects of under $5 million a year, so you can no longer do those for projects under $5 million. The bill also defines a discrete project, something to be aware of, so that if you have a public work project, you can only define it as one discrete project if it's on the same site. So if you have a contract to replace, say, all the boilers in all your county buildings and they're not on the same geographical site, that no longer counts as one discrete project. So something to be aware of.
It does or does not? It's one project or can be several?
It is current. Before there was no definition of a discrete project, so it could have been on several sites, but you could have called it one project. Now, one discrete project means it has to be on one geographical site. It could not be on multiple sites.
If you do.
Did I say that?
Oh, yeah, I got that part of it. So on the other side, if you're doing several projects on one site, is it all lumped as one project? I guess that's where my mind went. So
I would look at it and specifically see what other pieces of that definition there are for a discrete project, and have your DA take a look at it. I have the bill right here, so I'll look at it afterwards.
So to give you an example, we're looking in the next 3 years of building a government central complex in Dayton, which will be on about 40 acres and be 3 separate buildings. And our DA has said that the 3 separate buildings will all be built at the same time, so we will be okay in regards to how that was written. But if we're going to build one year and one the next year, one the year after, it'd be a whole different ballgame. Or if one was to be across the street, it would be an issue. It would be on the same 20 to 30 acres.
And the final one is SB 480, something for rural counties also to be aware of regarding justices of the peace, regarding when the number of justices of the peace can be increased in your county. So currently, you're required to have one JP for each town, and then when the population of that town, if it were to increase over 50,000, the law would require you to add another JP. That was reduced this session in SB 480 to 35. I'm sorry. I have that backwards. It was 35,000, where you were required to add another JP. It is now 50,000. So it increased that. Another important piece of this bill is that the JPs now have to consult with the county commission when a JP is added. So they're now required to come and talk to you if another JP is going to be added. So just something to be aware of. Only it's going to affect those counties as far as the townships. And that's all I have. We have time now for questions. If anybody has additional questions on any of the bills we discussed or any of the topics we discussed, please.
So SB 215. When will that? Oh, wait a minute. It goes into effect July 1st.
Right. For new claims filed after July 1.
Okay.
Extension provision.
Okay, I'm sorry, I had a different question on my notes. So that one, 215. Wayne, do you have any idea right now how much that might financially affect the counties?
We don't. We're meeting with our actuary to try to figure something out. But it's a significant potential because it's going for life on a fairly undefined list of potentials. So it's almost a speculative pick. Until the cancers develop, we see more of them. So we'll probably do an incremental increase just to have something in place until we get actual data developed. But it's just hard to predict. We're meeting with the actuary on Monday, so maybe we'll have a better idea after that.
So how is that affected for rural Nevada, or at least I'm not aware of how emergency services work. And some of the entities, they contract that out. Are those contract employees covered? Is that a tool that we could use doing those kind of services under contract rather than as employees? Am I saying anything relevant?
I will caution you, there was a case that did not involve one of our members, but our workers' comp counsel happened to be the counsel on the case. A private contractor hired a former fire chief from a public entity to be their director of fire operations, emergency operations. He had all kinds of lifestyle bad habits, and of course had a heart attack while he was working for that private contractor. He filed a heart claim, and there was a big debate. And the end result, the court said he is eligible for heart-lung coverage working for a private employer because it is not restricted to only public firefighters. So from that standpoint, contracting out isn't going to help you.
The county is still liable for the, okay.
Does it separate between fire and paid personnel? Or sorry, volunteer or paid?
Volunteers are
or is it
different.
the same? It's different?
Yeah. Full-time, under the heart-lung, it's full-time paid police and fire that are eligible. So part-time or volunteers have different categories.
Are there other questions?
I do have another one, 8070 on the open meeting law. Bless you. When does that take effect?
think it did, but let me confirm. October 1st?
Right at the end of the bill.
Doesn't it say either upon passage or July 1st?
Yeah, there's no provision in the bill for effective date, so it goes to the default, which is what, October 1?
Okay, thank you.
Other questions, any other bills anyone would like to talk about?
I've got one that I had no idea was even out there until I talked with my sheriff last week, and he's, tell me what's happening with this bill on the counties responsible for the pets of people that go to jail. Am I understanding that right?
I'm really
or the
excited.
people that die?
Unfortunately, Vince knows about that.
Yeah.
He's been working on it.
So it's SB 342 addresses notification requirements for animal services for detained individuals. So right now, the bill was pared down quite a bit. Because when it was first out there, I think there were a lot of counties that were concerned. There was going to be language requirements and all sorts of things. But the state, under the provisions of the bill, I don't have it in front of me right now, but we just worked on this. So the state has to create a template that counties will then use and be required to post in jails that notifies detained individuals who has their animal. In some counties, that's an easy answer. It's the sheriff's office. In other counties, it's more complicated. So they wanted some consistency about where people could find out information. Someone gets arrested, there's 2 dogs in the house. Those dogs need to be taken somewhere. And where they go, that information will be provided to the inmate. That's the requirement as it stands right now. So the only requirement for counties and sheriffs and jail operators is to post that information. We worked with this senator who sponsored this bill, Senator Scheibel, to get her started, and I worked with a lot of the counties to find out, all of them, to find out who their contact information is for that, but it's going to be up to the state to provide that template to you or to your sheriffs and have them post it. And the sheriffs, the only requirement would be that they'll have to post that information or provide it upon request.
I'm going to say so, but the greater question is who has the liability for the animals?
Well, that should already be determined in your county.
That was already in state law?
Yeah, that was already a provision that was in state law. So sometimes it's Humane Society, if there's a local Humane Society, sometimes it's sheriff. I think in one county it's one person that does all that, but that's already established in state law. This was more about notification. And there's some provisions regarding amount of time and how you recoup costs, but that's already a law. That's already in statute. So.
I'll just add, if you're not aware of it, people seem to be more value their animals even more than their children.
So Beverly, we actually had to go to court to get was it the I just had it the ad litem, the guardianship ad litem for someone's dog that was going to jail for 6 months. And we had to go before the judge to get appointed to take care of somebody's dog.
Any other burning questions? Well, I want to thank our panelists very much for their willingness to come and study these bills and provide us with this presentation. Our next workshop will be February 7th after the holiday season. We'll then have another 3 after that on different topics. The topic of the February 7th workshop is on how to write a county water resources plan, which is now a requirement for all counties to have in their county master plan. So stay tuned for additional information on that workshop. Thank you for attending today. Just a reminder, if my video works, it'll be up tonight on YouTube. There'll be a link on our website. You can share it with your colleagues. So thanks so much for your engagement and attendance, and thanks again to our panel.
email was that she canceled the meeting that she had at 11. I'm assuming to come here and then.
Sure. Sorry, I should have kept my mouth shut on the second meeting.
Yeah.
That was like the weirdest thing ever. Because Sarah's been contacting me for weeks.
Oh God, I can't believe I said that. What?